applications, writs for important constitutional matters, and advises banks and corporations. He is also engaged in domestic and international arbitrations under the auspices of the International Court of Arbitration of the International Chamber of Commerce (ICC) and the International Center for Settlement of Investment Dispute (ICSID). He will be discussing his views with us during the sessions. Next discussant to enlighten us on the topics of development of constitutional institutions is Dr. Cynthia Farid. Dr. Cynthia Farid is a Bangladeshi lawyer with experience in research, law reform, and a range of rule of law programming with INGOs, think tanks, and legal rights organizations. Having completed her bar from the United Kingdom and Bangladesh, she graduated with advanced degrees from Cornell Law School and the University of Wisconsin Law School. Her research interests include socio-legal history, constitutional and administrative law, and law and development. She has published internationally and is the organizer of 2 international research collaboratives of the Law and Society Association (USA) on South Asian legal systems and praxis in the Global South that have brought together scholars from around the globe. Now I will introduce the presenters who will present their research papers to the participants and attendees of the conference. First, I'd like to introduce Mr. Peter Reid and Ms. Gayanthi Ranatunga, who will present a paper on parliamentarism in Bangladesh, Lessons for Sri Lanka. Peter Reid has joined us from Scotland today. He is a Ph.D. student at the University of Edinburgh. His thesis examines the change from a Westminster system to one with an executive president in Sri Lanka, Guyana, and the Gambia, and the layered constitutions that emerge as a result. Peter also holds a master's by research from the University of Edinburgh, in which he compared the presiding officer of the Scottish Parliament to the Speaker of the House of Commons. Peter is broadly interested in comparative constitutional law. Peter is also co-author of Parliament, Law, History and Practice, which was published by Center for Policy Alternatives in 2019. The paper was jointly presented by Gayanthi Ranatunga, who is an early career researcher with the Center for Policy Alternatives in Colombo, Sri Lanka. She has an initial BA and Master of Arts in English Language and Literature from Wichita State University, Kansas, USA. She also has an MPhil in Race, Ethnicity and Conflict from the Trinity College of Dublin, Ireland, and an LLM in International Law and International Relations from the University of Bristol in the UK. Her research interests include religious orientations in post-conflict settings, such as, but not limited to, Sri Lanka, Somaliland, Buddhist extremism, Islamic jurisprudence, and African human rights. He remains an avid reader who enjoys Russian writers, past and present. Welcome to the session. And then we also have another paper presentation will be taking place in this conference. And the presenter is Dr. Norman Riayat, who will be presenting on judicial independence in Bangladesh and Pakistan comparisons. Dr. Norman Riayat is a postdoctoral fellow at the School of Law and Politics, Cardiff University. His project involves publication of a monograph and 2 papers on judicial independence in authoritarian and hybrid regimes. He completed his Ph.D. on judicial independence in authoritarian and hybrid regimes at the Department of Politics, University of New York in 2020. Now, I would like to introduce and welcome the moderator of today's conference session, who will be taking over the panel discussions from me, Dr. Chaudhuri Ishaq Ahmed Siddiqui. Dr. Siddiqui is the head of Department of Law and Human Rights at the University of Asia Pacific and also the Deputy Director of Sales. He is also a practitioner of the Appellate Division of Supreme Court of Bangladesh and regularly appears before the court in important constitutional matters. He is also a specialist on energy law in Bangladesh with a doctorate from the University of Dundee. Dr. Siddiqui publishes his research work regularly in national and international journals and textbooks. Ishak sir, the floor is yours. Thank you.
Thank you, Farhan. Thank you, everyone. Good morning to wherever you have joined us from all over on the world. I really want to thank the presenters for getting up so early to take part in this conference. I really appreciate their effort. I also want to thank our discussants for taking the time to come over here and give their valuable feedback on the papers that we presented in today's conference. So without further ado, now I kindly request Mr. Peter Reed and Ms. Gayantika to present their papers.
Hello, can you hear me?
Yes, we can hear you perfectly well. Thank you.
Perfect. All right. Hello, and thank you for this opportunity to present. In our paper, Parliamentarism in Bangladesh, Lessons to Sri Lanka, we examined Bangladesh's constitutional experience and provisions, drawing on comparative methodologies to predict how such provisions may fare in Sri Lanka in a transition to parliamentarism. Historical, cultural, and political similarities between the two countries make a comparison between them quite useful, with an eye towards predicting. Our selection is based on the most similar cases principle, case studies that control the variables as far as possible, by being as similar as possible in everything other than the factor we are researching, then that is the causal factor in any diverging outcomes. Our methodology isolates structural features of parliamentarism as causal factors on constitutional performance in the context of Bangladesh and Sri Lanka, and forecasts how these designs may affect politics in Sri Lanka based on how they fared in Bangladesh. Our comparison controls for constitutional history, socio-political practice, and military influence in both countries. Sri Lanka and Bangladesh both began at independence with the Westminster system, which has created an enduring legacy of domestic expectations of constitutionalism. Sri Lanka and Bangladesh also have a history of personalized, patronage-oriented dynastic rule. Although the military's role is not identical in both countries, we consider it to be similar enough to merit this comparison. Sri Lanka has never had a successful military coup, unlike Bangladesh, but the current president's use of military symbolism, appointment of military officials to civilian positions, and the use of the military to provide civilian services, especially in these times of COVID, make it more similar to Bangladesh than many other countries. Varying political tactics exist in Sri Lanka and Bangladesh. In the latter, parliament boycotts and hartals feature prominently, but are not a component of the Sri Lankan political landscape. With other variables constant, boycotts and hartals have negatively influenced parliamentary efficacy in Bangladesh, leading us to argue that a transition to parliamentarism in Sri Lanka will be more operational, as such boycotts are not a feature there in Sri Lanka. So what this paper fails to control for is the nature of the political divisions in Sri Lanka and Bangladesh. No parallel exists in Sri Lanka for the Awami League BNP acrimony, where politics are animated considerably by ethnic divisions and anxieties rather than a rigid party line, unlike in Bangladesh. Compared to Sri Lanka, Bangladesh's politics are relatively unmarred by historical ethno-religious tensions. Bangladesh's relative homogeneity and uniform Bengali identity accounts in large part to this. In Sri Lanka, which is a far more diverse population, historical rifts endure along ethnic and religious demarcations, all of which culminated in a near 30-year civil war, which ended in 2009. And now Peter will continue with further details. Thank you.
So thank you, Gayanthi, for that explanation of our case selection. I hope that everyone will forgive my voice, which is a little bit hoarse today. But hopefully, if I just speak a little bit slowly, everyone will hear me clearly enough anyway. So I'd like to give a little bit of background on Sri Lanka's constitutional history and our interest in this project. So the roots of the Sri Lankan Parliament lie in 1833, when the colonial proto-legislature was first established. Although the then Legislative Council's powers were very limited, this was always intended as the first move towards full self-government in the future. And changes in the council's membership and powers eventually resulted in the State Council of 1931, almost 100 years later, under the Donoughmere Constitution. Donoughmere Constitution. This was an executive legislative body comprising multiple committees. And finally, Sri Lanka's independence constitution, the Silbury Constitution, was passed in 1948. And under this independence constitution, the parliament consisted of two chambers, which were the House of Representatives and the Senate, operating under a Westminster model constitution. Sri Lanka became a republic in 1972, and the new constitution actually removed many of the safeguards which the Silbury structure had installed. And the cornerstone of the first Republican constitution was parliamentary sovereignty. And it also established a unicameral legislature known as the National State Assembly. This was then replaced with the current constitution in 1978. So the 78 constitution consciously incorporated many aspects of the Fifth French Republic into Sri Lanka's institutions. Most significantly, Sri Lanka changed from a parliamentary system into a semi-presidential one. So this means that there was a directly elected president, and executive power was split between the legislature and the president. In 2015, the 19th Amendment to the Constitution enhanced parliamentary control over the cabinet, I should say. However, the system changed back again under the recent 20th Amendment. So there are strong arguments for a return to parliamentarism in Sri Lanka. A democratization campaign in 2014-2015 was one of the most significant political processes in the country's history. Under this movement, politicians from polar ends of the divide came together in calls for Yaha Palanaya, or good governance. And reformers were elected on a mandate to abolish the executive presidency. And the reformers won both the presidency and a parliamentary majority. Now, as I mentioned, the resulting 19th Amendment only weakened the presidency and restored some of the parliament's executive control. However, the campaign process crystallized some context-specific interactions between Sri Lankan society, politics, and constitutional design. So there's a deep compatibility between Sri Lankan democratic, republican values and parliamentarism on the one hand, and more hierarchical ethnocracy and presidentialism on the other hand. So perhaps far from representing the values of the French Republic or America's founding fathers, monarchical symbolism has been used to synergize Sri Lankan presidentialism with an alternative to constitutional democracy. And I should clarify that this wasn't a program to remove the electoral character of the state. However, it has been hostile to minority rights and scrutiny of the ruling elite. Parliamentarism is sort of seen as a way to de-reify the head of government and increase scrutiny of the executive. So I'll now discuss some specific experiences in Bangladesh that are important for Sri Lankan constitutional design. In this paper, we've discussed 5 areas, which are the head of state, political accountability, floor crossing, parliamentary committees, and Bangladesh's technocrat ministers. So in this paper, we actually give a lot of space to the design of the head of state in a future parliamentary system in Sri Lanka. This may seem a little bit surprising at first, considering the ceremonial role of a president under parliamentarism. However, the reason that we do this is that the corrective role that even a ceremonial president might have is often overlooked in the literature. Presidents in parliamentary systems tend to be seen as just a puppet of the Prime Minister carrying out their rule vicariously. However, we think that this should not be the case in all of the president's functions in a Sri Lankan parliamentary system. So that's why in this paper we actually use the term presidential corrective rather than ceremonial president to describe our proposals based on the Bangladesh experience. So the broad lesson that we think Sri Lanka ought to take from Bangladesh is that while the powers of the president ought to be limited, he should not be constitutionally deprived of all of his discretion. And also an indirectly elected president ought to command the support of a base that goes beyond simply the governing party. So this term, parliamentary systems with presidential corrective, it builds on studies of previous European systems, which were often seen as semi-presidential, but with particularly weak presidents. So examples of this include the two earliest European instances of semi-presidentialism, which were Finland and the Weimar Republic. We would propose that powers such as the right to return a bill for reconsideration, or to ask the Prime Minister to reconsider advice to the President, or to question that advice, are appropriate powers for a president in Sri Lanka. In Bangladesh, where the President acts almost exclusively on the advice of the Prime Minister, there have been calls for the President to have more formal power or discretion in this area. There is nonetheless there is a precedent in Bangladesh for the President returning a bill for reconsideration against the wishes of the Prime Minister. Although this wasn't necessarily envisaged under the Constitution. So there are also presidential powers in Sri Lanka and Bangladesh, which would be better exercised by other authorities. The President of Bangladesh exercises important powers, including the power to appoint the Attorney General, senior judges, and commission members. Subject to some restrictions, the President may also prorogue and dissolve Parliament. In all the functions, apart from the appointment of the Prime Minister and the Chief Justice, the President must act on the advice of the Prime Minister. Therefore, the Prime Minister exercises by proxy some of the most important state powers, which modern constitutions would normally entrust to impartial authorities. Particularly successive governments have used the President's powers to politicise civil service appointments in Bangladesh. And this is also an issue in Sri Lanka. It's an issue which actually the previous 19th Amendment framework went quite a long way towards remedying. So we argue that these are powers which modern constitutions ought to trust to impartial commissions rather than cabinet through a figurehead president. Bangladesh demonstrates that the corrective president ought to have cross-party support rather than only the support of the governing party. The president of Bangladesh is indirectly elected by the parliament. Calls for reform have often included the need to diversify this appointment process, particularly to include local governments and a mandatory level of opposition support. Now, it should be noted that although the president's appointment does relatively little to separate the office holder from the cabinet in Bangladesh, for the president's removal, a two-thirds majority is required in the Jataya Sangsad. In the case of Sri Lanka, it's especially important for the president to function with the trust of religious and ethnic minorities, as well as whichever party is in power. In this paper, we also see Bangladesh as something of a warning against presidential ordinances. So MPs, including government backbenchers, have been irritated sometimes by government's proclivity to introduce laws as ordinances in Bangladesh and then expect Parliament to pass a corresponding act. Worse still, these ordinances are sometimes flagship laws, and when turning them into ordinary legislation, the proper procedures aren't always followed. So I'll turn now to our second point of comparison, which is political accountability under a parliamentary system. Bangladesh has introduced accountability mechanisms which would export well to Sri Lanka. Because Sri Lanka does not suffer from boycott politics, these mechanisms could even have more success than they have in Bangladesh. So in Bangladesh, the Prime Minister and Cabinet are now more accessible to MPs, allowing for more effective scrutiny and institutionally engaged politics. Even in a centralised and quite authoritarian political climate, backbenchers and opposition MPs have been able to exercise some influence over legislation. Furthermore, in early parliaments after democratisation, the Speaker was quite diplomatic in accommodating unscheduled debates tabled by the opposition, which encouraged parliamentary rather than protest politics. So we found that a weakness in accountability identified by Bangladesh commentators is the government's tendency to announce important policy decisions away from the dispatch box and deliberately avoid engagement with MPs. Such conduct really goes against the grain of parliamentary democracy, and we found that there's maybe a good argument for codifying rules around policy announcements to be made within the Parliament, to actually codify these within the Constitution. Now, the absence of boycott politics in Sri Lanka means that parliamentarism would function more effectively, we think, than in Bangladesh. When a parliament operates under Westminster procedures, in particular Westminster model procedures, the key role and power of the opposition is to scrutinise the government policy and practice. This means they need the right to be heard, the right to call on ministers to answer questions, and good resources as well to keep them informed. But if the opposition isn't present, and of course the government can effectively run the country without political scrutiny. Boycotts have not been institutionalized in Sri Lanka as they have been in Bangladesh. The closest which Sri Lanka has really come to boycott politics is perhaps some Tamil political movements. But even the Tamil population is not monolithic, and voting patterns can't easily be directed by the leaders. Our third point of comparison, I realise I'm running a little bit short on time here, but I'll quickly come to the end. Our third point of comparison was floor crossing. And we found that in both countries, in both Sri Lanka and Bangladesh, party leaders exercise quite severe control over MPs' independence, and then that this is enshrined in the Constitution. And we realise that there in neither country are there easy answers to this. I mean, of course, there's always value in having independence for MPs. We also need to ensure that systems are stable enough to function properly. So I think that when we looked at this issue, we found that perhaps the best thing that can be done is just a cross-fertilisation of debate, which could be taking place between both countries, which have fairly similar rules. In Sri Lanka, MPs can lose their seat if they're expelled from their party, whereas in Bangladesh, MPs can lose seat after voting against their party. So I'll now turn to Bangladesh's committee system. A well-structured committee system is of course an effective tool to allow bipartisan discussion of legislative detail, and also encourage opposition and backbench influence over government legislation. They allow governments to pass legislation they need, while also opening the door to opposition expertise, which other parliamentary proceedings aren't normally conducive to. So Bangladesh's fifth and seventh parliaments made significant efforts to enhance the role of committees. And although the overall picture isn't necessarily a positive one, there have been tangible successes that offer hope for the future. Particularly, committees have at times allowed for more cross-party cooperation than is possible elsewhere. And also the government has been willing to accept amendments proposed in committee. And these are sometimes significant changes to the bill. So our final lesson as it were, from this comparative study was Parliament's innovation in Bangladesh's innovation in technocrat ministers, who are unelected members of cabinet appointed under Article 56(2). Technocrat ministers are limited to a tenth of the overall cabinet membership. And under Article 73A1, these ministers may take part in proceedings, including votes insofar as they relate to their respective ministries. So that this is an innovation which is uncommon. It's not unheard of, but it's quite uncommon in Westminster modern democracies. And the Sri Lankan system does allow for a number of appointed MPs. However, this doesn't seem to have been used to bring in expertise, to bring in technocratic expertise. So we found in other studies that technocratic appointments globally don't normally, or they don't necessarily remedy the key complaint that they're designed to address, which is a lack of expertise in the legislature. We found that the governments tend to favour experts with real-world knowledge and political experience. They found that these experts tend to have their most trust when bringing them into the cabinet. They tend to function the best. So they also look for experts with political canny. Nonetheless, in Sri Lanka, it might be a good idea to include in the constitution some goods that technocrat ministers are designed to achieve. So explicitly mentioning that they're there to bring expertise into Parliament, and perhaps also diversity. We also feel that, as in Bangladesh, there ought to be a cap on their proportion within the cabinet. The 1/10 proportion seems fair, and we also added that the great offices of state, as they were known, so Chancellor, Foreign Secretary, Home Secretary, ought to be drawn from elected cabinet members. We think that this could better ensure that these ministers balance the influence of the Prime Minister and cabinet. So I think I'm slightly over there. I'll just very quickly wrap up. Those are the sort of, that's the background to this study and the key lessons that we thought we could draw on from the Bangladesh experience and trying to envisage future constitutional change in Sri Lanka. Thanks very much for listening to our presentation there, and I'll pass it back now if that's all right.
Thank you, Peter and Galantika, for your presentation. I thought it was a very enlightening piece on the comparisons between Sri Lanka and Bangladesh, the institutional developments in regard to the constitutional making of the parliaments of both these two countries. Now I kindly request Dr. Noman Riyad to present his paper. Dr. Riyad.
Can you hear me?
Yeah, we can hear you perfectly.
Thank you very much for giving me this opportunity to share my thoughts on comparison of the higher judiciaries in Bangladesh and Pakistan on this very occasion, the completion of 50 years of Bangladesh Constitution. So today I'm going to compare the nature and scope of judicial independence in Bangladesh and Pakistan. But before presenting my main argument, let me explain what do I mean by judicial independence. I mean the increase or decrease in both de jure and de facto judicial independence. And these two components are not static. A certain degree of judicial independence exists in almost every country, and hence treating judicial independence as if it has a static nature does not explain anything. It is dynamic and either increases or decreases. The increase in de jure judicial independence, by that I mean the increase in guarantees available to the judiciary in a constitution or a legal document against undue influence by other branches of the state. The increase in de facto judicial independence means the increase in judicial power, which is visible in the successful protection of the court against any court packing or court curbing actions by other branches of the state, decisions made by the court against the political interests of other branches of the state, and the implementation of those decisions. By court packing, I mean the other part, the removal of a judge or appointment of a judge who is expected to behave in favor of the executive or the appointing authority. Court curbing actions of a regime means restrictions on the powers of the court by the executive or parliament. Now, why here's a question arises: why I'm not looking into the impartiality aspect? And this is the question most of the time I receive, that what if a judge is a political actor, and if he is behaving in accordance with the political consideration or in context, and if he is not behaving in accordance with the law? Now, my answer to that is impartiality is a myth. It's almost impossible. Judges are humans.
Dr. Riyad, could you please kindly speak a bit slowly so that it's easier for everyone to understand? Just a bit slowly. Thank you.
Yeah. So the impartiality aspect is a myth in context of South Asia, where judges, like all other humans, they are human. They have got emotions. They they receive different information and they process that thing, and they cannot detach themselves from the context. And especially in a South Asian environment, which is a caste-based, tribal, full of tribal affiliations and family connections. So that is almost impossible to expect them to behave in accordance with the law. So in short, they are not robots. And that's why I didn't look into the impartiality. And another reason for not looking into the impartiality aspect of judicial independence is that, is the decisions of the higher judiciaries, they create losers or winners. So both of them have got reasons, good reasons to accuse judges of being political. And if it is the political involvement, then there are a number of cases in the UK and the US context that can easily prove that judges are political actors, and hence they are not impartial. So that's why I didn't look into the impartiality context. Now, courts in this paper refers to the Supreme Court of Bangladesh and the Supreme Court of Pakistan. I compare these two courts and do not compare other tiers of the legal system, because all decisions of the lower court ultimately reach the appellate jurisdiction of the Supreme Court. And hence that variable of the implementation of the decisions, we cannot examine unless it's, people will keep on challenging those decisions, and it will not attain finality until it reaches the higher judiciaries. Now, a significant degree of de jure judicial independence existed in both Pakistan and Bangladesh since their independences in 1947 and 1971, respectively. There were 3 constitutions in Pakistan: 1956 Constitution, 1962 Constitution, 1973 Constitution, and 1 constitution was enacted in Bangladesh in 1972. Now, the preamble of all these constitutions, they in Bangladesh and Pakistan formally provides that the independence of the judiciary shall be fully ensured. These constitutions of these 2 countries protected the process of judicial appointments, and until 2005, Pakistan case was similar to Bangladesh regarding the process of judicial appointment, that judges of the Supreme Court and the High Court shall be appointed by the president after consultation with the Chief Justice. The process of removal of the judges' powers and jurisdiction of the Supreme Court and provincial high courts in case of Pakistan, and the perks and privileges of the superior judges. So all these constitutions provide some kind of formal independence. Now, the wider literature on comparative constitutional law and politics give explanation for judicialization of politics, constitutional politics, and constitutionalism. but very few studies, specifically focus on the concept of judicial independence in authoritarian and hybrid regime like those in Bangladesh and Pakistan since 1947 and 1971, respectively. These studies attribute judicial independence to constitutional designs, like constitutional provisions, and the main lesson is because the constitutional provisions empower the judges, and that's why they behave, in a certain way. Legal history, legal culture, or political competition, the strategic framework. Almost none provides an interdisciplinary account of judicial independence. But this is my attempt to fill the gap by providing such an account. And by doing so, I'm kind of suggesting that constitutions are important in terms of providing a broad framework and boundaries between institutions, but a combination of social, political, and legal factors, that are equally important and that we need to look into. Had it been the constitution is there since 1972 in case of Bangladesh. In Pakistan, the last constitution is there since 1973. But we can see the increase in judicial power, over a time at specific junctures, which are shaped by these different legal, political, and social factors, which I'm going to explain now. Now, my main argument is that judicial independence increased and maintained itself after 2005 in Pakistan and did not emerge in Bangladesh because of three factors. The first factor is socioeconomic changes, which gave rise to the middle class and media in both Bangladesh and Pakistan almost at the same time, and created an opportunity for the judiciary to engage with the middle class and media and cultivate their support through independent behavior against the political interest of the ruling regime. Now, explaining this factor in case of Pakistan, the military regime of General Pervez Musharraf back in, from 1999 till 2008, massively privatized, sectors, including banking sectors, telecommunications, and privatization created jobs and small-scale business opportunities, resulting in a huge portion of the population joining the middle class. This class consisted mainly of those who were able to provide paid skilled services. They were upwardly mobile, educated, and salaried people, including professionals, teachers, lawyers, and students. As a result, Pakistan was ranked in the top 10 countries of the world by the size of its middle class. However, with the rise of the middle class, the demand for more jobs, good services, more access to the state, and a rule-based system increased. Now, on the other side, the means of mass communication and opportunities to spread the message, by institutions, individuals, were limited before 2000, the first decade of the 21st century. Telecommunication was one of the sectors privatized during the military regime of General Pervez Musharraf. And as a result of that privatization, the access to information increased. Before 2000, there was one state-owned television channel in Pakistan, and it was not broadcasting 24 hours a day or the live transmission. Similarly, before 2000, there was one radio network called Pakistan Broadcasting Corporation. After the privatization of this telecommunication sector in the early 2000s, hundreds of private channels with the ability to broadcast 24 hours a day were launched. Now, this factor created an opportunity for the judiciary to cultivate the support of the middle class and media by protecting their rights, especially when the demand for, when the dissatisfaction of the middle class with the ruling regime was all-time high in case of Pakistan. So the middle class and media can contribute to the successful protection of the judiciary through anti-regime and pro-judiciary demonstrations or anti-regime litigation, which encourages the judiciary to behave independently. And I will explain this later when I will talk about the factor of judicial leadership. In Bangladesh, socioeconomic changes such as the rise of the middle class and media took place around the same time and at a similar rate as in Pakistan. economy of Bangladesh has grown over 6% annually in the last decade. Its status has changed from low income to lower middle income. As of 2019, per capita income was $1,500. As of 2021, the total population is estimated to be 160 million, 25% of which falls in the middle class. However, unlike unlike Pakistan, the different surveys and the different public opinion service reports, such as the International Republican Institute in 2015, showed that 67% of population supported the government and the incumbent regime of Prime Minister Sheikh Hasina. After this victory in 2014, the support maintained and it kept on increasing. Now, similar to Pakistan, media in Bangladesh was monopolized by Bangladesh television until the late 1990s, which was similar to the situation in Pakistan. Like the Pakistan Broadcasting Corporation, Bangladesh Betar had a monopoly over radio broadcasting. The privatization of electronic media began with the establishment of channels such as ATN Bangla in 1997, Channel I in 1999, and Ukashir Television in 2000. As of 2020, there are 45 private televisions, 28 radio channels, and over 1,000 daily newspapers in Bangladesh. And the viewership also is kept on increasing. Now, this fact, unlike the media in Pakistan, the rise of the media was not followed by increasing engagement between the media and media and the Supreme Court of Bangladesh. And I will explain later, how this engagement increased, and this engagement was visible in public interest litigation and the demonstration for the support of the higher judiciary in case of Pakistan, but not in case of Bangladesh. Unlike the Supreme Court of Pakistan, the Supreme Court of Bangladesh did not rely upon media sources in public interest litigation massively. The second factor is the divisions within elites. Now, the first factor I explained was the socioeconomic changes, the rise of the middle class and the media, and the opportunity created for the judiciaries, higher judiciary in two countries, to behave independently and cultivate the support of the media and the middle class. But the second factor is divisions within elites, which divides opposition to the judiciary, the executive pressure and the parliament's pressure. It divides the opposition to the judiciary and creates an opportunity for the judiciary to behave independently of the ruling regime and cultivate its support. The support provided by the first and second factor can protect the judiciary against court curbing and court packing actions of the ruling regime. But this third factor creates space in the sense that the judiciary, it signals to the higher judiciary that the pressure of the executive cannot be exercised in a way in the same way in which an authoritarian regime or a strong regime with two-thirds majority can exert on the judiciary. There's always some degree of friction between opposition political parties and the ruling party in Pakistan and Bangladesh. Since 1947 and 1971 in two countries respectively, you can see this thing, and which created opportunities for the judiciary to use the conflict between political opponents and behave independently. However, the Supreme Court of Pakistan was able to use this opportunity to cultivate the support, only after 2005, because the presence of a strategic and popular Chief Justice who was willing and able to do this. In contrast, the Supreme Court of Bangladesh could not use this opportunity consistently between opposing parties in their favor to gain autonomy from the executive and behave independently. When behave independent, especially before 2008, when governments in power were weak and did not have absolute majorities in parliament. The reason for the inability of the Supreme Court of Bangladesh to take advantage of the opportunity was the lack of a strong and popular judicial leader in Bangladesh. However, Awami League secured a two-thirds majority in the general elections of 2008, 2014, 2018, and these regimes are strong, and hence the Supreme Court of Bangladesh did not feel encouraged to behave independently of the government by making decisions against its interest. Now, this leads me to the third factor, which is equally important, and that is the emergence of a strategic and popular judicial leader. Now, there are existing studies on judicial leadership, judicial heroes, and recently the Cambridge publishers, they have published this multi-authored edited book on towering judges, which suggests that this judges, individual judges, sometimes make a difference, and they are a very important factor in examining and analyzing the nature and scope of judicial independence. So when I say the emergence of strategic and popular judicial leadership, who is willing and able to lead the judiciary to take advantage of the opportunities created by the first two factors. Now, the presence of such a judge can utilize all these opportunities created by the factors I explained before. By strategic judge, I mean who is aware of socio-political, socio-economic context and how to use that context in favor of the court against other branches of the state. By popular judge, I mean a judge supported by distinct groups or classes of society, either through anti-regime and pro-judiciary demonstrations, just like in Egypt, Pakistan, Poland, or anti-regime litigation. Now, litigation is also a mechanism through which you signal to the judiciary that we trust you and you have got our support, so that they feel encouraged that, okay, fine, our implementation compliance will be there. These groups can support that compliance. Now, until 2005, the socioeconomic changes and divisions within elite factors were present in Pakistan, but the judicial leadership factor was absent in Pakistan. However, this factor emerged in the shape of Justice Chaudhry, who was appointed as the Chief Justice of Pakistan on 30th June 2005. Justice Chaudhry was the most strategic judge in the judicial history of Pakistan, because he was aware of the above, the opportunities I explained, the factors I explained, but chose not to avail himself of them until he became the Chief Justice. The behavior of the Justice Chaudhry changed after his appointment as the Chief Justice of Pakistan. On the day of his appointment, he made a speech which clearly signaled that he was aware of those opportunities. He is aware of the middle class, vibrant civil society, and the media. And the speech reflected his intentions and plans to engage with the media and the middle class. So the Justice Chaudhry increased engagement with the media and the middle class, by lowering down, by increasing slow motor cases notices on all those issues which were predominantly appealing to the middle class, and lower the locus standi of petitioners under Article 143 of the Constitution, which empowered the Supreme Court to enforce the fundamental rights and make decisions on cases pertaining to public interest. Now, initially, the military regime tolerated this behavior, but when the Supreme Court of Pakistan, under the leadership of Justice Chaudhry, harmed the core interest of the regime, then the military regime of General Musharraf retaliated by suspending Justice Chaudhry. The suspension triggered mass demonstrations by civil society organizations, journalists, lawyers, students, and opposition political parties. And this is the thing which is missing in many other authoritarian hybrid regimes, present in case of the Judges Club of Egypt, and in recent times in Poland as well. Now, the suspension of this Justice Chaudhry signaled the judiciary executive conflict, which motivated opposition political parties to support the restoration of Justice Chaudhry and create space for themselves by making General Musharraf unpopular for his attack on the independence of the judiciary. Until this stage, the Supreme Court of Pakistan added the support of opposition political parties to the supporting structure. At the same time, they challenged the suspension of Justice Chaudhry before the Supreme Court of Pakistan, directly challenged in the wake of demonstrations and petitions the Supreme Court of Pakistan restored Justice Chaudhary, which indicated that there was an attempt of court packing, but the court successfully protected itself against the court packing action of the regime, and that too an authoritarian regime. However, General Musharraf again sacked Justice Chaudhary, this time along with other judges of the Supreme Court and Provincial High Court, with the proclamation of emergency on 3rd of November 2007. But it took 2 long marches, first in 2008 and then in 2009, long marches for the restoration of the judges removed on 3 November to restore all of these judges, which again indicated that court packing actions, the court protected itself against court packing actions of the authoritarian and hybrid regimes, and that too through a popular process, demonstrations, not through a constitutional change, not through some kind of a series of verdicts. And that indicates the increase in de facto independence of the Supreme Court of Pakistan. After the restoration, we can see the petitions, direct petitions before the Supreme Court of Pakistan after the restoration in 2009, not soon after the enactment of Constitution in 1973. The petition increased from 0 in 2008 to 6,784 in 2010, and then 16,270 in 2012, which suggests that the trust in the Supreme Court of Pakistan increased massively. And it was signaling to encouraging the judges to behave independent. On the other hand,
may I just kind of request you to wrap it up in the next couple of minutes? Thank you.
Last few lines. On the other hand, the judicial leadership factor was missing in Bangladesh. Different chief justices of Bangladesh had delivered bold decisions against the political interest of the executive. For example, in Salimullah versus Bangladesh, former Chief Justice of Bangladesh declared the caretaker government unconstitutional. But none of the Chief Justices of the Supreme Court of Bangladesh, let alone individual judges, take any significant actions to engage with the middle class and the media to cultivate their support. They could not mobilize heterogeneous societal groups against the regime. And my findings, all of the above 3 factors are equally essential for the increase in judicial independence in authoritarian and hybrid regimes like those in Bangladesh and Pakistan. Strong and popular judicial leadership is unable to do anything without finding an opportunity to strengthen the judiciary against other branches of the state. Similarly, the availability of opportunities to cultivate supporting structures will not mean anything if the Chief Justice leading the higher judiciary is not willing and able to take advantage of the available opportunity. Thank you very much.
Thank you so much, Dr. Ria. That was very interesting observation in regard to the Supreme Court of Pakistan and the Supreme Court of Bangladesh. I think we'll get a lot of questions on that. I just want to remind everyone, if you have any questions, please type it in directly to me or Mr. Saleh Akram, and we would be asking those questions after the panelists give their feedback. And in that vein, I'd kindly request Dr. Cynthia Farid to kindly give her feedback on the 2 papers that have been presented. Dr. Farid.
Thank you. I really enjoyed reading both the papers. I thought they were excellent interventions in the sense that this is a regional conversation, which is refreshing from some of the more functional comparative constitutional projects that you see elsewhere, where post-colonial countries are usually the subject of this kind of external gaze from the global north, and also consider deviations from sort of Western notions of legal institutions. So all that said, South Asia is a very interesting place for all of these legal and constitutional developments. Bangladesh, with its 50 years of experience, I think we're at a critical juncture to kind of assess and evaluate what's also going on in the region and Bangladesh's place within all of these regional developments. So with that said, I was struck by some of the things in both the papers. So I'll start with the first paper. I was struck by what you mentioned in the paper as controls. And I think if you mention controls, maybe actual empirical data might be helpful, keeping with your focus on structural design. It would probably help to look at certain events or certain incidents or certain developments that occurred because of certain structural designs and how they differed in Bangladesh versus Sri Lanka. So if you look at the development and expansion of parliamentary power in Bangladesh, it has been complex. Bangladesh has experimented with both parliamentary and presidential systems. So that on its own, I think is a big similarity. And I think you shouldn't be afraid of highlighting that in the paper, just sort of right at the beginning. Also, it has been ruled under more than one military dictatorship, but with each passing regime, of course, what we see is that the centralized nature of the state has been reconsolidated. And also the centralizing and the consolidating tendencies in the state stem from this bureaucracy-centered colonial sort of structure that we inherited, and also the kind of contemporary politicization of structures of governance. So the comparison which the authors have engaged in this sort of the case studies that they've engaged in is what Harshan Kumarasingham has termed as Eastminster. So I do hope that you look at his work for the origins of what we call Westminster style parliament, right? So Eastminster, which is basically the British legacy of parliamentary institutions, not just here in South Asia, but also elsewhere. So if you look at kind of Asian legal elites at the point of decolonization, so even when they were engaging in criticism under colonial rule, were thoroughly acculturated in British political norms. And this was reflected in their political regime choices, despite some of the demographic disparities and the prevalent cleavages. So British accounts of the Westminster model uniformly relegate the sovereign or their representatives to a solely ceremonial role. In contrast, in Eastminster heads of state in sort of British Asia, if we can call it that, some of these legal elites profess that these systems were modeled on the British royal template, but you also see these elites engaging in political activism, and many saw themselves as having personal prerogatives, which then encouraged them to intervene in politics, right? So you have examples of sacking and selecting prime ministers, ministers, commanding the military, formulating policies, chairing major committees, directing the cabinet and the civil service, and completely ignoring the legislature at times. So these are generally unheard of in Britain, or let's say the settler states, Australia, for instance. So the principles of responsible government also in some instances were overturned. Additionally, historically, the two-party system was seen as critical to the practice of Westminster government. Eastminster, like much of the Commonwealth, did not exhibit conditions that make a two-party system operable. And this situation was, of course, not helped by the traditional majoritarian first-past-the-post method, and more often than not, one-party dominated politics, whether that's in sort of contemporary South Asia, or if you look back at the Muslim League or the Indian National Congress or coalitions of elites such as the Ceylon's UNP, which was created with the purpose of receiving power from colonial rule, right? So all of this, in many instances, have rendered opposition a very lonely and a heroic occupation, right? Secondly, the Eastminster provided very few incentives, and this is, I think, very relevant for Sri Lanka as well, that there were very few incentives of the system to the kind of the balance between center majority to protect and accommodate minorities, right? So in Sri Lanka, for instance, the linguistic rights of a major minority were removed by a parliament dominated by parties seeking the majority community's support, and went through requiring just a show of hands and without breaching the constitution. So throughout Asia, right, the political realities dictated that minority rights were ultimately secondary to majority ambitions and realities. And politically, the majoritarian mechanics embedded into the Westminster suited the Eastminster leaders, who invariably came from the dominant group in their society. Minority rights, whatever their legal status, owed their success or failure to the precarious realm of the political exigencies of the center, which often functioned without credible minority representation. And also, if you look at the evolution of this system, the government of India was almost uncritically accepted, particularly as it made its way from India, Pakistan to Bangladesh. And the most controversial elements appropriated were the emergency provisions, which a lot of the anti-colonial nationalists had, with good reason, spent much time and ink decrying to the colonial power. So those same leaders were then quick to accept and adopt the same powers. And in the chaotic times that followed independence, there were creative use of conventions so intrinsic to British constitutional life, which proved valuable to Asia's governing elites as a means of stifling opposition. So if you take the Pakistan 1954 fiasco of dissolution of the legislature, that's a case in point, which actually followed 17th century English precedents. So anyway, all of this to say that, perhaps looking at some of the ways in which it evolved in this part of the world might actually enrich some of the discussions that the first paper is looking at. The second paper, which again, I thought the comparisons were very useful. I don't think a comparison of this sort has been done in the past. That said, I would encourage the author to focus on some of the aspects, and I'll go through some of the headings, or at least in terms of the three factors which he identifies. So one of them is the kind of socioeconomic changes in the middle class and its nexus with the judiciary and how that impacts judicial independence. I think what is being presented here is a case of judicial populism, and I would encourage you to look at Yasser Qureshi's work on judicial populism. Popularity with the middle class here, coincided with a PIL moment, particularly in Bangladesh. And this was a case that was similar in India in the post-Indira Gandhi moment, and also in the South Asian incarnation of PIL, in which we see significant judicial activism, is in many ways distinguishable from the Anglo-American experience, right? So in South Asia, you have the judiciary taking on issues of socioeconomic justice, state repression, and governmental lawlessness. But if you take the United States, for instance, the public interest litigation discourse and the kind of judicial power is grounded in notions of civic participation in governmental decision-making to secure greater fidelity to parlous notions of legal liberalism and interest group pluralism. So for this section, I think the media discussion that you engage in can be truncated somewhat because the media and the judiciary have not always had an amicable relationship. I mean, we can cite tons of examples where the media and judiciary were actually in loggerheads as opposed to in a relationship of cooperation, which then takes us to the second issue, which is the emergence of divisions between elites. And here I was a little bit surprised to not see an extended discussion on judicial appointments, which I think is an important factor. And also, I think is at the center of elite friction and conflicts. And thirdly, the emergence of a strategic and populist leader. I would encourage you to perhaps not make the sweeping claim about the absence of a strategic and populist leader. And I would encourage you to look at the background to the Eighth Amendment case in Bangladesh, which established the basic structure doctrine. So this case presaged popular mobilization, resulting in the ousting of a military dictator. And each one of those judges who ruled in those cases went on to be chief justices, and they were excellent leaders. But you have to bear in mind that sort of our golden period was this kind of transition, like the next decade after democratic transition, particularly within the judiciary. But you have to bear in mind that this is also a period in that decade which was preoccupied with the caretaker government and transition to power. And the judiciary was in fact providing an integrity functions for elections, right? Making sure that elections were free and fair. I would also encourage you to perhaps look at the historical background. I know there was a claim in the paper, also in your presentation, that legal history and culture tend to be irrelevant, but I think there is a great deal of relevance of the path dependencies and colonial continuities that plague South Asian systems across the region. There are good reasons why separation of powers, particularly separating the judiciary from the executive, was included in South Asian constitutions, but largely as aspirations and not in the main chapters of the constitution, right? So separation of judiciary and executive were sort of aspirational goals that were to be achieved sometime in the future. And separation of judiciary from the executive is not a new problem. It has been a protracted problem in the region since the late 18th century. You can go all the way back to the Regulating Act of 1773 and the creation of this nascent kind of state apparatus and courts. Also, if you look at kind of early 20th century political claims, both the Indian National Congress, the Muslim League, and kind of other offshoot parties that ultimately contributed to the partition and so on and so forth. All of these resolutions, they included demands for separation of powers and judicial independence. And courts were operating under intense authoritarian conditions then too, but there were ways of not just political activism, but also activism from the bar, and the courts plugged in judicial independence in a way that kind of, there was de facto judicial independence, even if there wasn't de jure judicial independence. One last point, which is checks and balances downstream within institutions, kind of vertical checks and balances. Bangladesh does not have a prosecution service, but Pakistan adopted one, if I'm not mistaken, sometime in 2005. And I think these controls within institutions are just as important for judicial independence. And I would really encourage you to perhaps look not just within the judiciary, but also in the kind of ancillary support institutions that enhance judicial independence. I'm going to end there. Thank you so much.
Thank you so much, Dr. Fareed. I would maybe the presenters can come back to respond to some of the queries that she has given, and maybe could answer some of her feedback as well. Now, I'd kindly request Mr. Mustafizur Rahman Khan to give his feedback on the papers presented.
Thank you very much, Dr. Siddiqui. Unlike most of the, certainly unlike the presenters as well as the other panelists, my own academic credentials are much more modest. I am essentially a practicing lawyer. Nonetheless, the reason perhaps why I have been invited by Dr. Siddiqui to have a few words here in this particular seminar is because recently we had an opportunity to work together in the context of a particular case. And during that time, we had some opportunity for exchanging some idle views. And in that context, perhaps Dr. Siddiqui was interested in some of the views that I had expressed. And I will take this opportunity to expound upon those views. Some of it will also echo on what has been presented by the two in the two papers, as well as some of the comments that Dr. Sindhya Fareed has also made. Now, I was very interested in Dr. Nauman Riyad's presentation, and particularly the factors that he has identified, which affects the independence of judiciary in a country like Bangladesh. Now, one of the areas which I believe is very important when you consider the independence of the judiciary is the role of the bar. And this is something which Dr. Fareed had hinted upon when she mentioned the 8th Amendment case. The 8th Amendment case, for those, certainly for the younger participants in this particular forum, is perhaps the zenith as far as the Supreme Court of Bangladesh is concerned, insofar as its role in protecting the rule of law in Bangladesh, the democracy in Bangladesh, as well as the basic structure of the Constitution of Bangladesh. And that zenith was attained because of a partnership between the bar and the judiciary. The 8th Amendment case, I believe it was in 1988. The context of the 8th Amendment case very simply was this: by the 8th Amendment of the Constitution, which was precipitated by General Ershad's government, the Supreme Court was bifurcated into 6 or 7 or 8 benches throughout the country. And this was challenged in the Supreme Court as offending the basic structure of our constitution, which is a unitary constitution. And before this particular case was brought to the court, it was preceded by 2 or 3 years of movement from the end of the bar, from the side of the bar, during which the members of the executive committee of the Supreme Court of Bar Association had to even undergo imprisonment. There was a period for a couple of years when the Supreme Court Bar Association actually boycotted the court. And what happened at that time was the lawyers used to prepare the briefs, send them over to the court. The briefs were presented by the clients themselves. That was just a mere formality. What the judges did were they actually looked into the brief and made their determinations accordingly. I think this is a very significant episode in our legal history, which has not been researched, which has not been commented upon in the halls of academia. But this collaboration that actually took place between the judiciary and the bar in the period between 85, 86, 87, 88. I myself was not a lawyer then. I am not that old, but nonetheless, this is something which has been relayed to me by my seniors during the course of, again, cups of tea in the Bar Association. But this collaboration was very significant, and I hope that this is something that the academia will look into. That, as I said, that was the zenith of the bar in protecting the independence of judiciary in Bangladesh. We saw a faint echo of that in 1994. The subject of judicial appointments have also been touched upon in the course of the discussions that preceded my own meager contributions to this forum. But in 1994, what happened was that the Chief Justice was not consulted by the then BNP government while making some judicial appointments. There is no constitutional requirement for this, but there is a convention to the effect that the Chief Justice will be consulted when judicial appointments are made. Now, this convention was ignored by the then ruling BNP government in making some judicial appointments. Even gazette notifications were published. But the Chief Justice refused to administer the oath. The Chief Justice at that time was Shahabuddin Ahmed, who was later president. And before that, during 1990, he was the acting president after the fall of the Ershad regime. So he said that, very famously said that I have been reduced to Mr. Nobody. I have not been consulted in the making of these judicial appointments. What is very interesting is that the government of the day, the BNP government, actually backed down. And the reason why the BNP government backed down from that situation was the very robust leadership that was provided by the bar at that particular time. The late Sayyid Ishtiaq Ahmed comes to mind. He, along with other such senior lawyers, including Dr. Kamal Hussain, Barrister Moinul Hussain, I believe, they all went to the president and then went to the prime minister of the day. The then law minister, Mr. Mirza Ghulam Hafiz, also had a very constructive role in ensuring that that particular episode had a happy ending, in the sense that the Chief Justice was finally consulted. 2 or 3 of the names which were put forward for appointment to the High Court were actually withdrawn. Now, what happened in 1980 and 1994 is in contrast to what has happened in more recently in 2017, when we saw the rather ignominious exit of Chief Justice Surendra Kumar Sunha. When this is something which Dr. Noman has touched upon in his paper, what was not apparent when Sinha, Chief Justice Sinha, was subjected to this ignominious exit in September 2017 was there was no massive protest from the bar, even though the bar at that time was led by the office bearers. The elected executive committee of the bar at the time were more sympathetic to the opposition, or the de facto opposition BNP government, because BNP is no longer in the parliament as well. And that was very disappointing to see, for me to see as a member of the bar. I often say, and I'm saying this in the context of academia, the greatest tragedy that happened in the political history of Bangladesh in the past 50 years was the 15th of August 1975, when the father of the nation, Bangabandhu, was assassinated. But I think the second biggest tragedy in Bangladesh happened during the circumstances of Justice Sinha's exit. It is something which happened without any bloodshed, but nonetheless, on that particular day, a pillar of our constitution was actually assassinated, and that passed without any serious comment. The weakness of the judiciary in that particular episode is also remarkable, because basically what happened, the other 4 senior members of the Supreme Court, of the appellate division of the Supreme Court, they were called into a meeting, or at least 3 of the 4. One of them was traveling abroad. 3 of them were called in by the Honorable President, who handed over a dossier listing certain alleged irregularities against Justice Sinha. Constitutionally speaking, what they should have done, the next 4 judges or the next 3 judges, is that they should have told the president that we are not going to look at it. The Constitution provides for a mechanism of referring allegations about misconduct against a particular judge, in this instance, the Chief Justice himself. Please refer it to the Supreme Judicial Council. We will look at it at then, in that context. Instead of responding in that particular manner, which I believe would have upheld our Constitution, they actually went back to Sinha, Chief Justice Sinha, and said that we will not sit with you. This is very ironic, because the apex judiciary itself failed to rise to the occasion in order to protect judicial independence. Now, this is a very recent episode in our political history. I'm only discussing it freely in the context of an academic discussion. It is still a very raw nerve, because Sinha is the immediate preceding Chief Justice. But nonetheless, I believe that this is something which has to be looked at by the academia. I am merely a lawyer. I can only give you anecdotes in that particular episode. But now I would like to touch upon something that Dr. Naumann has identified, that there are also socioeconomic factors which are at play. You're absolutely right. This is something, again, which requires a bit more empirical research. I think one of the reasons why the bar failed in 2017 to rise to the occasion is precisely the socioeconomic development of Bangladesh. As you have very rightly pointed out, despite everything, or perhaps because of everything, Bangladesh has made significant economic strides in the past 50 years. Bangladesh has graduated from the ranks of a lower income country to a lower middle income country. This means that the state has become much more richer. Since the state has become much more richer, there are now there are more opportunities for the state doling out patronage with which political loyalty is purchased. Dr. Farid mentioned about the necessity of having an independent prosecution service in Bangladesh and how that may impact upon the independence of judiciary. Well, my own academic credentials are rather limited, rather modest, but this is how I see it. In Bangladesh, because the government in power uses various opportunities of making appointments as a currency of patronage in order to buy political loyalty and also to reward political loyalty. What has happened in Bangladesh is that because the state has become richer, there is now much more to dole out. For instance, appointments in as lawyers of different state-owned corporations, appointments in the Attorney General's office, appointments in the Public Prosecutor's office, appointments in the Government Pleader's office, in the subordinate judiciary and district courts. Now, the prospect of such patronage is something, in my view, prevents the coalescing of the bar in order to take a united stance when it comes to being more robust in defending the independence of the judiciary. This is something which has changed in the past 30 years. And this is a surprising, or rather a unwitting effect of the economic development of Bangladesh. It is perhaps, again, an area which is worth having academic inquiry. Of course, Bangladesh, unlike Pakistan, has not been able to set up separate laws for judicial appointments. Judicial appointments happen. There is no transparency in the way in which judicial appointments happen in Bangladesh. Judges are appointed by the president upon the advice of the Honorable Prime Minister. I noted that Dr. Naumat Riyad mentioned that the president, or rather not Dr. Naumat Riyad, rather the first president, Mr. Peter Reid, mentioned that in Bangladesh, the Chief Justice is actually appointed by the president. Well, that is what is there in the paper. Practically speaking, even the Chief Justice is appointed upon the advice of the Honorable Prime Minister. The most recent appointee as Chief Justice, the current Chief Justice, Mr. Syed Mahmood Hussain, himself is a beneficiary of a supersession. According to the convention, after Sinha departed, the next senior most Chief Justice, the next most senior judge, Mr. Justice Wahab Mia, was supposed to become the Chief Justice. Now, I have it on good anecdotal authority. I cannot show it on paper, that the president himself wanted to appoint Mr. Justice Wahab as the next Chief Justice.
Mr. Khan, let's not get specific.
No, I will get specific.
No specifics, please.
Dr. Siddiqui, I will get specific. I apologize for that, but I will get specific.
Let's not get into the process.
This is an academic discussion. I think we should not be unafraid to talk about sensitive matters, taking names as well. This sort of self-censorship is something which rather exacerbates the problem. Anyway, so I think that that is also something which is worth inquiry. That is something which has to be looked at by the academia. The other two factors before I leave, or rather three factors, which I would like to touch upon, which affects the independence of judiciary in Bangladesh, is that there is a certain opacity in the way in which the judiciary works in Bangladesh. At the risk of sounding a bit patrician, the socio-cultural background of judges have changed over the past years. I think that is something which is also worth academic inquiry in the tradition of critical legal studies, Scandinavian realism, American realism, which you see in countries abroad. We do not see a parallel to that in Bangladesh. It's high time that this should be there. One of the issues which, as a practicing lawyer, I see, which affects my practice, is this. Nowadays, judges, some of the judges who are appointed have background from certain universities, and these alumni associations are very robust in their activities, which is fine. There is no problem in it, but sometimes the fraternization between judges and members of the alumni association who are from the bar introduces a layer of, how shall I put it, opacity in the way in which justice is administered in Bangladesh. Again, this is a subject matter which requires some empirical research. The reason I say this is not to stoke controversy, or the other aspects upon which I touched during my previous remarks is not to stoke controversy, rather to invite academia to look at upon these different threads of investigation in order to apply proper empirical research in order to, give us a better understanding of the legal system as it is working, and also hint at opportunities for reform. The last point that I would like to mention, and this is something that I picked up from Dr. Naumat Riyad's paper, which was otherwise extremely illuminating and very interesting in terms of, pointing different directions of further inquiry. You remarked that both Bangladesh and Pakistan are federal republics. They are not. Bangladesh is a unitary republic. Okay. And the Bangladeshi unitary republic, the fact that Bangladesh is a unitary republic places its own challenge on our legal system, which also has an effect on the independence of judiciary. Now, in terms of population, Bangladesh is the largest unitary republic in the world. This is something which I have not seen commented upon by academia, but I believe this is something which places unique challenges and unique pressures on our judiciary. Again, I repeat, in terms of population, Bangladesh is the largest unitary republic in the world. And for that reason, our Supreme Court's workload, sheer workload of our Supreme Court is without parallel. The sheer workload of our judiciary is without parallel. For instance, forget about the Supreme Court. In the subordinate judiciary, in the magistrates court, a typical magistrate in Dhaka has to dispose of 300 applications for bail during the course of a day. It is not possible, humanly possible, for a magistrate to give a judicially reasoned order while disposing an application for so many applications for bail. He basically has 2 minutes or 3 minutes to look at a bail application. Now, this is placing its unique pressures upon our judicial system, which is adversely impacting upon the quality of justice which is being delivered, and also the administration of justice. The other thing which has an impact upon this, unitary structure of our republic and the structural pressures on our legal system is again precisely attributable to the development of Bangladesh. The modern state is a franchise state where different activities are licensed. Increasingly, you have to look at very complicated issues. So when it comes to judicial review applications, very often you will find that we are coming up with issues which are technical in nature. For instance, regulation of a telecommunication company or regulation of an oil company. And these are issues which are very difficult for our judiciary to deal with in the summary jurisdiction of the summary writ jurisdiction. And very often the courts invariably have to bow down to whatever is the view of the executive. It's because the circumstances are such that they are not adequately resourced to look into these issues. So this is something which again has to be something which I believe is a matter of academic scrutiny, the unitary character of our republic, how it is putting a pressure upon our legal system. The last and this is the elephant in the room, the lack of democracy in Bangladesh. This has, we all know what happened in the elections of 2009, 2014, 2018. Dr. Siddiqui should rest relieved. I'm not going to expound on that now. But nonetheless, this lack of democracy is creating its own problem in Bangladesh. Basically, what has happened in Bangladesh is that the government in power is there because of a combine between the bureaucracy and the military in Bangladesh. And the bureaucratic military elite in Bangladesh increasingly functions beyond the pale of judicial and political accountability. Parliament is incapable of holding them to account. The courts are also incapable of holding them to account. And unless we restore a functional democracy in Bangladesh, I think the future is bleak. And it's so very ironic because at the same time, economically, Bangladesh is developing. Dr. Namat Riyad has commented that the Awami League government was elected. I'm not mentioning about the elections themselves, but the fact is that even if there were to be free and fair elections in Bangladesh, my own personal opinion is that the Awami League would still get a slim majority at the very least, because of the fact that economically the country is developing, the middle class is acquiescent and happy. As long as they are making material progress, they don't really matter what's happening to the constitutional institutions in Bangladesh. So there is this, tacit acceptance of the middle classes and the business elite of what's happening in Bangladesh, and that is contributing to the process. Just one last point. You commented upon the way in which the 13th Amendment was made unconstitutional. If you look at the history of elections in Bangladesh, you will find that in every election that was held under the auspices of a caretaker government, the last government which was in power, the last political party which was in power lost the elections. By the same token, whenever a political government was in power in holding an election, invariably the political government in power won. So that actually points to the importance of the caretaker system that had developed in Bangladesh and how effective it was in protecting at least a functional democracy in Bangladesh. And the way in which that system was gotten rid of by Khairul Haq Chief Justice's court. And remember, Khairul Haq himself was appointed as Chief Justice out of turn, meaning that by convention, he would not have been Chief Justice. He was made Chief Justice by superseding somebody who was senior to him. And in the ordinary course, he would have retired before becoming a Chief Justice. So the fact that his appointment as Chief Justice done by a president who was de facto acting on the advice of a prime minister, this is also something which may be looked at in the context of academic research. So thank you very much. So that's my contribution.
Thank you, Mr. Mustafizur Rahman Khan, for your feedback and comments on both the papers. I personally thought the floor is now open to questions. I will request the audience to text or write the questions directly to me, and I can ask the questions to the presenters. I thought both the papers were extremely interesting, and they were looking at two very important institutions, which plays a very integral part in upholding the constitution of any country. And I wanted to ask a question to Peter and Gayantika both. And the fact that you have compared the parliamentary system of both Bangladesh and Sri Lanka, my question to you is, do you think that the power given to the president in Sri Lanka has been curtailed after 2015? And do you think that actually helped constitutional matters in Sri Lanka, or parliamentary democracy for that matter?
So I think that there's a well. First of all, I'd like to say thank you very much to both the discussants for fantastic comments on the paper there. That'll be really useful for taking this forward, I think. And then this question about whether the powers of the president were really curtailed at all, I think it ties in a little bit also to this discussion of exactly what sort of role the president ought to have. I suppose that the key change from the balance of executive power that was introduced during that process was the parliamentary control over cabinet and its composition and survival. And these changes, of course, were done away with immediately after the most recent round of elections in the form of the 20th Amendment. So in a sense, I think that they weren't really given a chance to be properly sort of experienced. And to understand what changes just that 19th Amendment could have made to the system in the long run. And then we didn't really go into this very much in the paper, but of course there's been lots and lots of discussion in Sri Lanka about what happened after 2015 and then in the constitutional crisis that followed. And then I think the consensus is that this was about the personality, the personalities involved, rather than the structures that were introduced. And essentially, no matter what the structures were, it probably wouldn't have gone any other way, because that was just the personal political dynamics at the time which determined the outcomes essentially. But even then, of course, I mean, there were interesting moments in that constitutional crisis which showed quite a lot of institutional strength, which can be overlooked sometimes, I think. Both in terms of the Supreme Court standing up against an illegal dissolution of Parliament, and also the MPs and Speaker himself, who stood up against attempts to manufacture a parliamentary majority. And also through prorogation procedures, which we touch on slightly in this paper, but which are an interesting sort of remnant of a lot of these Westminster and Westminster model independence constitutions, which often haven't been gotten rid of, even though this. I think it's difficult to justify them in the modern age. So yeah, in short, I think that probably the 19th Amendment just wasn't given a long enough run to see actually what changes in political culture that amendment itself could have introduced, and whether in the long run it would have significantly changed the role of the president, or the position of the president.
Right. And it's interesting the fact that you've also talked about the role of the technocratic ministers, and you compared that with Bangladesh, right? I mean, why do you actually think that technocratic ministers would actually be helpful? Because these are unelected people, and they obviously bring onto the table various expertise, no doubt about that. But why do you think that experience from Bangladesh is actually going to help Sri Lanka?
So yeah, it was something that sort of caught our attention, because there had been, or from my perspective, the sort of the UK Constitution. I examined this before a few years back, the then Prime Minister Gordon Brown also tried to introduce something similar to this through appointments to the House of Lords that were then brought into the cabinet solely on their technical expertise. So the sort of personal interest was sort of peaked from that, and then I think that in the context of Sri Lanka, this could be one of those useful things which can balance some of the concerns that people can rightly have about a change to parliamentarism, where the head of government is naturally subjected to just a much more limited pool of expertise compared to what you have in a presidential system, at least in theory, and then of course in a context where there can be a lot of distrust in politicians as well, of course, and wanting to bring in the sort of game changers from outside, as it were. I myself am totally convinced that this is some sort of great change in practice. And this is some sort of constitutional provision which can really enliven a cabinet. I'm not convinced of that, but I think it could be at least a useful, at very least, it could be something useful to take care of very legitimate concerns, and also it's as long as it has some proper restrictions. It probably shouldn't do at least any harm either, and some new expertise could possibly be brought in that wouldn't be there otherwise.
Right, good. Thanks for those clarifications. Now, going to Mr. Dr. Riyad, if you would like, you can respond to some of the feedback that you got from our discussants. And I also like you to answer or want to know your opinion about the fact of the concept of separation of power, right? I mean, in your paper, you discuss a lot about the Supreme Court of Bangladesh and Pakistan getting into the realm of policy making. Now, you have three independent organs of the state, and obviously the Supreme Court of Bangladesh and to Pakistan to some extent have the right to fend off anything that comes within their turf. But when do Supreme Courts in both these countries, should they be making policy decisions, legislating, when actually that's the domain of the parliament, right? So please respond to some of the comments of that, and if you may kindly answer that question as well. Dr. Riyad.
I think let me start with this, your question, and then I will go back to separation of powers. So the basic understanding is judiciary has to interpret, legislature has to legislate, make law, and executive has to execute the law. Now, if this is fine, I mean, this is something I'm quite okay with that. But in the field, when I interviewed judges, and more or less it was the responses of the Polish and the Egyptian and the Pakistani judges quite similar. And this, and this is the conflict, the understanding, and that's the question itself, which needs further exploration, at how different elites understand this definition, and then the society. When you ask, civil society organization representatives or litigants, how do you see judicial independence? And they say, where is judicial independence? Fundamental rights are not protected, and this, so on and so forth. But when you ask judges, they say, okay, fine. If the protection of the fundamental rights is our domain, then what about the parliament, and what about the executive, and what about this understanding that we only are supposed to interpret the law? And this is where many judges in the UK, and especially in the immigration cases or the terrorism related cases, they say the same thing. We have to interpret the law. You put law before us, and we are supposed to interpret the law. We are not supposed to protect or think about other things. Now, as I said in my presentation, in our authoritarian and hybrid regimes, where there's a lot of de facto things going on. So military affects, influences things there in Egypt, Pakistan. and on different occasions in Bangladesh as well. But is it documented? Is it like, can we record? Can we prove that it's happening there? It always happens from behind the scenes. So in this context, this theoretical understanding of separation of powers almost becomes irrelevant, and the lines between different institutions that are that seems to be blurry. So you cannot rigidly separate. Another response, I would like to respond that when we talk about law, we need to understand that law is a product. You expect the judiciary to interpret the law, but the essence of the law itself is political. It's the intertwining nature. It emerges as a result of a political process, debates, and the political considerations. And ultimately, when it reaches the law, where the judges have to see the framers' intentions and different other things, depending upon those approaches, they have to interpret the law. Lines, inherently become blurry. So it becomes difficult to say, like, judiciary has to do this thing, and this is the only job, and Parliament has to make the law. And also, if you ask, if you go to the judgments, they do justify this thing, consistently from the beginning till end, that we are not making the law, and we are only interpreting the law. Even though they are actually making the law, they do involve in the policy making, but they do justify that they are not making the law. Now, coming to the responses, briefly, quickly, I will respond. First, the federal state, and I think that's very important to respond to the federal state thing. I agree with you. I need to explain more what do I mean by a federal state. I think you're quite. I agree with you. No different thought on that. That theoretically, Bangladesh is the unitary state, and Pakistan is the federal state, and same goes for the U.S., Canada, and other Germany, other federal state. But recently, the developments, there's a growing literature which suggests that when it comes to the judiciary and the role of the judiciary in different areas of policy making, politics, this difference between the federal states and the union state is becoming slightly irrelevant. For example, after Devolution Act in 2003 in the UK, where in this country, the devolution, the powers distributed among different tiers of the judiciary and the Supreme Court, and how different Scotland, Ireland, and England and Wales, the distribution of powers among them, it presents, and there are a lot of studies there which suggest that it's a quasi-federal, or should we say that it's a theoretically unitary, but practically it's a federal state. Because if you go from one unit to another, different laws, different legal system, not entirely, but to a large extent. But I do agree with you. I need to add this, explain this thing, that what do I mean when I say because it sounds like it's unitary. I'm saying it's also theoretically Bangladesh is federal and Pakistan both are federal. Now the second, you mentioned, Mustafi's mentioned about the 1994 case, and it's quite similar to what we say judges case in context of India and in Pakistan. So the Al-Jihad Trust case in Pakistan and Sadri case in Pakistan, and same there case of Anandan case in India. It's quite similar, when it comes to, but the socio-political context is different, and it's quite illuminating, which the empirical evidence which you shared with me. And the rest of the responses, comments, yeah, I think that more or less I agree with you, and I need to take all these things into account. Yeah, and in the end, I will say, I'm very grateful to both of you. Feedback was very rich, and in one word, it was very illuminating, mind-blowing for me. Especially the Mustafi's, it was quite overwhelming, but fully, very enriching. Thank you.
Right. I just wanted to follow up on one of the comments that was made by Mr. Mustafiz as well, and this question to Dr. Brat as well. maybe in your paper, as Mustafa has pointed out, the role of the bar is pretty important as well. And also when you are talking about social mobility in your paper, I think social mobility is very important in regard to the new lawyers coming to the bar, and also the judges who are selected from the same bar, because the notion of being a lawyer has changed a lot. I don't know about Pakistan, but it has changed a lot in Bangladesh. A young lawyer now coming to Bangladesh or being enrolled to the bar is more interested to make money and to present their case. I mean, nowadays, for example, you do not actually see young lawyers having a senior, right? You see more young lawyers wants to get quick cases, wants to make quick bucks. And 15 years down the line, or 25 years or 20 years down the line, when the same person becomes or is in a position when he becomes a judge, his way of thinking, it's more transactional, you see? And that is why I think that is something which you need to take into consideration. And it might be similar in Pakistan as well. And maybe that is something which could also enrich your paper, right? So the social mobility is not only for people in general. Obviously, people in general have their own understanding of what law is and what we should be doing. But I think the bar and the bench, especially in terms of quality, in terms of principle, that is something which should also be taken into account, right? I do not have any other questions from anybody. Oh, I have a question actually. Actually, a question for the discussants, all right, to Dr. Cynthia Farid, on the reflection on diversity in the judiciary and comparative perspective, and also on the constitutional scholarship in South Asia and the scope for developing this further and prospects for exchange. Barrister Sarah Hussain has asked this question. So what is your comment on that, or what is your take on that?
Can you please repeat the question?
Yes, so basically your comment is diversity in the judiciary and comparative perspectives, and also on the constitutional scholarship in South Asia and the scope for developing this further and prospects for exchange.
It's that's a tall order for me to answer.
It's pretty broad, yeah. But
in 5 seconds, I think in terms of diversity, I mean, I think judicial appointments and the way it's done, also, I think the state of legal education, it's basically whatever you're producing from the law schools, is what's going into the profession, right? Whether it's the bar or the judiciary. And I think diversity there, it's really dependent on what the law schools are producing. And I think if you look at the state of our law schools, both public and private, not just us, but across South Asia, right? Because if you look at Indian law schools and the curriculums and the way kind of it connects to the profession, I think that we certainly have some way to go. And one of the things that I saw while I was doing some research in the Calcutta High Court, for example, was the ways in which pupils were paired up with judges. So you're kind of like preparing young people from a very young age. And I think that also, there is no sense of that in our judiciary. But in terms of constitutional law within the region and how it's written about and scholarship within the region, I think it's expanding. For a long time, I think it was somewhat legalistic, somewhat non-interdisciplinary, but I think that is changing. For a long time now, I think over the past maybe 5 years, comparative constitutional law, certainly within the region, and if you look at Global South constitutionalism generally, I think there is this critique that it was largely functional, and it was largely legalistic without really looking at the on-the-ground developments of what's happening. So I think we probably need, in terms of improving that, we probably need more empirically grounded work. To be honest, like in the last sort of, I mean, I returned after a long hiatus back to Bangladesh, and I've actually just started going back to courts. And in my last couple of weeks of intensely going to court every day, I'm sort of thinking at this point, I have to unlearn so much, because so much is happening that you don't read in the books. Like so much of it is what you're having to learn from just interactions. There are certain court conventions, and none of this is captured in the current kind of scholarship. So I think it certainly needs to be more empirically grounded. And when I say empirically grounded, I don't mean necessarily quantitative studies, which are great, but I think that sort of really looking at what's going on and kind of that needs to be reflected in constitutional scholarship, not just in Bangladesh, I think within the region in general. So I hope that answers the question. Thank you.
Right. I have a question for Basaros again, for all the presenters and the discussants as well. And the specific question is, we have constitutional commitments across the region on gender equality and non-discrimination based on caste, religion, race. And there are new statutory duties re-eliminating discrimination against people with disabilities or on grounds of sexual orientation or gender identity. How do you see these issues being addressed in representation of judiciary? One example is in Bangladesh. We are challenging Bangladesh judicial service rules which bar people with disabilities from being recruited. Baisar Khan, do you want to comment on that, or what are your thoughts on that?
I think, again, my own contribution would be anecdotal. Recently, there has been a judgment of our Supreme Court, which I found very interesting. There was this lady who stood first in the Qazi enrollment examinations, marriage registrar enrollment examinations. She was not recruited. She came first. And she challenged this action in the Supreme Court of Bangladesh. Now, our High Court has given a judgment saying that there are certain cultural or religious functions that are supposed to be discharged by the marriage registrar, which a female marriage registrar may not always be in a position to discharge by going to a mosque. And for that reason, the rule was discharged. Her challenge failed. Now, I'm not sure whether this will be escalated to the appellate division, but with all due respect to the Supreme Court of Bangladesh, and what was particularly remarkable was that one of the two judges of the bench which delivered that judgment was a woman. Now, I think that there is some way to go before we see gender issues being, properly addressed as far as our judiciary is concerned. And on a slightly different note, I am very grateful to Dr. Siddiqui for raising another issue, which is of concern to me personally. It is the approach of young lawyers these days. I mean, during the 80s, 90s, we saw young lawyers coming forth who had a commitment to constitutional issues pertaining to human rights and gender rights and so on and so forth.
I think we lost Baisar Khan there. Peter, do you want to give your comment on that, please? On the question of gender equality and non-discrimination based on caste in the judiciary in general, based upon your studies in South Asia, Bangladesh, and Sri Lanka. Peter?
Yeah. Sorry. It seems to be another one of these issues which seem very, very difficult to investigate from the outside, as it were, where the written word and practice seem to be very different, and it seems like the anecdote which we've just said there is a great example of that. Yeah.
Right. And Dr. Riyad?
I think there are two aspects of this gender equality, and it relates to this debate of judicial diversity, and it's very, very popular debate here in the UK. And I think I still remember related to this issue, I presented a paper comparing Australia and the UK, and the question was about judicial diversity. I agree with you that the representation of different genders. And when, this also we need to take into account when we say gender, it's not like female or male. It's all about all gender groups. There are different other gender groups. Their representation on the bench and in the bar is quite, is far lower than what their population is. In case of Pakistan, it's quite visible. India, it improved relatively compared to Pakistan or other South Asian states. The reason, what's the reason? The reason is, one of the reasons is, which Mustafiz mentioned, the socioeconomic background. And also it is present in the Rand Hirsch's thesis. When the state, the dominant majority, the dominant majority groups occupying the state positions, they share an interest. And they not only, they make laws, or they interact with each other in a way in which ways and paths to the other ethnic minorities as well as gender minorities, it gets restricted. They're not going to give space to them, because it's literally giving them with an opportunity to challenge the state authority. So this is one of the reasons. But the second reason, if I am self-critical, I will say, if I'm critical of my own argument, I would say that we also need to think about that if this equation between gender and decision making, isn't it against the theory of separation of power, which you mentioned? So for example, there's a tendency, and this is what I notice in debate on judicial diversity, that they keep on advocating there must be more representation of females or other BAME, LGBT groups in the on bench and in the bar. But do we mean to say that if a female is going to decide female issues, that will serve more justice than if a male is going to decide? This equation between decision making and gender seems to be a bit dangerous in relation to the theory of separation of power, because in that sense we are saying that actually powers are not separated. The separation of powers are actually dependent upon other factors which are non-legal, which are not something based on laws. That's it. Thank you.
Right. Thank you, Dr. Riyad. I think we're nearly finished over here. I basically want to thank both the three presenters for presenting their paper. I also want to thank the discussants as well. I think the main focus of this conference, and we're going to have another segment this evening as well, and I want to invite all of you to attend that at 6 p.m. Bangladesh time on a very interesting topic as well, and tomorrow morning as well, 9:30 a.m. Bangladesh time. And I think the main purpose of holding this conference was to discuss very important critical issues. And since Bangladesh is celebrating its 50 years, and we're actually going to celebrate the 50 years of our constitution next year, next November. Being one of the countries born relatively late compared to the other South Asian countries, I think we have made a lot of progress, but still a lot more needs to be done. And there is a lot we can learn from other South Asian countries, not only South Asian countries, but other countries which were born or which got independence during the same time as well. And the purpose of this conference is to basically get young academics to present their papers, and also to get panelists and discussants who are both academics and also practicing lawyers or practicing in their profession, so that we can get feedback from those two important segments of people who can bring in their perspectives and can give their feedback. So I thought both the papers were were extremely well put down, and the feedback that has been given by the panelists, I'm going to email both of you again with the references that has been given by one of the panelists, so that will help you to incorporate those observations in your paper. And I want to thank all the people attending today's conference for taking the time to do so. We feel very encouraged by this, and especially the presenters. It's You guys are 5 hours behind, and 4 a.m. in the morning in the UK. And it takes a lot of commitment, and I'm really, really, really grateful to both of you, and also to Ms. Ranatunga. I mean, she's come to us from Benin. So thanks to all of you. Thanks to all the people who attended this conference. And I also want to thank Blast, Sales, and also the University of Asia Pacific for helping us organize this. So thanks again. And I want to invite you again to our next segment at 6 p.m. today. And I hope all of you have a very nice day. And good morning again, or good afternoon to those in Bangladesh. Thank you.
Thank you very
Have a
much.
blessed day.